The problem with work is no one knows what's in the fine print.
Now, sign here and we're all done.
Alrighty.
Read the small print.
What?
Thank you, Noodle, that'll do.
Oh, what'd you say?
Who's that in?
The girl.
What girl?
That girl. It sounded like read the small print, and there does seem to be a lot of it. Oh.
Like young Willy Wonka, you might not have read the fine print on your employment contract and might have signed away more rights than you realized.
Well, that all seems to be in order.
Really?
This is Fast Company's The New Way We Work, where we take listeners on a journey through the changing landscape of our work lives and explain exactly what we need to build the future we want. I'm Fast Company Deputy Editor Kathleen Davis. One in 5 American workers have signed a non-compete clause in their employment contract, and many likely had no idea what they were agreeing to or its impact on their future employment.
I was shocked. This is the demand letter I got.
In 2019, Courtney's former employer sued her for almost $200,000, claiming multiple breaches of her contract, including this competitive
As you may have
clause.
heard, earlier this spring, the Federal Trade Commission banned the use of non-compete clauses in employment contracts for most workers. But the ban is facing a lot of legal challenges and is far from being in effect. Non-compete clauses typically prevent workers from joining competitors for a certain period of time after their employment. While many people are only vaguely aware of these clauses or assume that they are only used in highly lucrative, competitive, or secretive industries, they're actually applied to a surprising number of jobs, including low-wage jobs, and have far-reaching effects. In fact, the FTC claims that the ban on non-compete clauses would generate extra job opportunities for as many as 30 million employees and raise wages by $300 billion. To help explain the reasons both for and against non-compete agreements and the impact they have on employees is Evan Starr. He's an economist and professor of management and organization at the University of Maryland who has studied non-compete agreements extensively. Evan, thank you so much for being here.
Thanks, Kate. It's a pleasure to be here.
So let's start with the most basic. What is a non-compete agreement and are there different types?
Sure. A non-compete agreement is typically just a few sentences in an employment contract that stipulates that when the worker leaves, they can't go join or start a competing business, typically within a time frame, which is 1 or 2 years post-employment, and typically within a geographic area, which could be a few miles from the place of business, could be within the state, it could be within the whole US or even the world. There are differences that are important. Some non-competes tend to be longer. Those tend to be at the kind of top levels of the company. And some tend to be broader in terms of the geographic coverage. What you'll typically find in like a sales role where you're serving local clients or customers, those restrictions tend to be a few miles from the place of business.
And so what's the history of non-compete agreements? When did they start and is there a time where they kind of became more widespread?
Non-compete agreements go back a long ways. The very first case related to non-compete agreements came about in the 1400s in England. They arose in the Guild era, where master craftsmen would train apprentices. You can think of sort of a mason who's a master mason training an apprentice, and the apprentices would work for several years to become trained in masonry, for example. And then after they became fully trained masons, the master mason wouldn't want the apprentice to compete with them in the product markets. And so they would ask them to sign a non-compete agreement. The first known non-compete case dates back to 1414. And the way that the European courts handled them at the time was, they were very skeptical of non-compete agreements because it prevented a worker from providing a valuable public service and earning a living with their skills. And then in 1711, there was a case that said maybe non-compete agreements serve some valuable purpose, like incentivizing master craftsmen to train apprentices. And so this is where we kind of get the idea that maybe non-competes can be good, even though they do restrict workers. And in the US, we basically ported over this common law. And, it was in the 1800s where several states started experimenting with non-compete law. And this is where you get California, Oklahoma, North Dakota, all in the late 1800s, banning non-compete agreements, while most other states chose to enforce them as long as they were reasonable. If you fast forward a little bit in time, we don't really know when non-competes sort of take off. I think there are some hypotheses that the decline in unionization rates after World War II, coming down to today, where less than 10% of the workforce is unionized. They had collective bargaining agreements that covered all workers. But as unions declined, we ended up with individual employment contracts, with an individual worker having an agreement with their employer. And somewhere in that time period, non-compete agreements, we think, became more common, though we don't have definitive evidence. And what we see really is that legislators started picking up on this in approximately, I want to say 2008 was sort of the first time where legislators in Oregon began to realize that non-compete agreements were being used in low-wage worker contracts, and they started taking issue. And then it rose really to national prominence in 2014 and 15, when there were several high-profile examples of non-compete agreements being used with Jimmy John's sandwich makers and temporarily employed Amazon packers who were paid $13 an hour. And these examples sort of, really bolstered public policy interest. And since then, we've had several surveys and other evidence documenting their use. But really, that interest came about in 2016 and later.
There's so much that's so fascinating there. I had no idea that it had that kind of long tail. I think a lot of people, either have no knowledge of non-compete agreements or a vague knowledge and think, they associate it with high wage industries, with the tech industry. I know you've done a lot of research on the impact of non-compete agreements with low wage workers. What are non-compete agreements used for in these low wage jobs?
The employers themselves would argue that they're using them either to protect their legitimate business interests, which is a legal term that's required to enforce a non-compete. And those would be things like trade secrets, client lists. So in the Jimmy John's case, for example, I'm sure they think that how they put together the meat and the cheese and the sauces in their sandwiches is some sort of trade secret that they're trying to protect with the non-compete agreement. They might also claim that they are using their non-competes to invest in specialized training for their workers. And I think that's the kind of company perspective, is that they're using them for these sort of legitimate reasons. I think if you want to be less favorable to the companies that are using them for these low-wage workers, you could think that they're using them for some malevolent means, which is just to make it harder for their workers to leave a job. They could be using it to try to tamp down wages to the extent that a worker gets another offer in the industry. The non-compete could prevent them from taking that offer. And of course, there could be some just, they just use these terms because they're boilerplate, and it's costly to rewrite contracts for thousands of workers. And so once you come up with a set of terms that works, you just use them for everybody. And there's not a thought given to it aside from, this is our contract.
And how widely do they vary? I mean, in a non-compete agreement that a Jimmy John's employee is signing, how wide-ranging can it be? Is it that you cannot work for any restaurant at all, any sandwich maker? Is it usually by more precise industry or a wider swath?
Yeah, that's a great question. It's going to vary based on the type of job. For example, the Jimmy John's non-compete that came about in 2014 said you can't work for 2 years after you leave within 3 miles of any Jimmy John's at basically any food shop that makes 10% of their revenue from sandwich-like items. And so that would be kind of most food establishments. And if you're in, for example, Chicago, where there's a lot of Jimmy John's sandwich shops, it would be very hard for you to get a job in the kind of food industry. If you look at Amazon's non-compete, the one that was found with a temporarily employed Amazon packer, that one is a global non-compete. It doesn't have a geographic restriction. It's an 18-month non-compete that prohibits an employee from, and I'll read part of it here to you. It prohibits an employee from engaging in, support, the development, manufacture, marketing, or sale of any product or service that competes or is intended to compete with any product or service sold, offered, or otherwise provided by Amazon.
So everything in the world.
Yeah, they produce a lot of stuff. So it's a very broad non-compete agreement. And so they do vary a lot. When you ask about the prevalence of non-competes, I think that most people tend to think of C-suite executives, high-tech workers. And it's certainly true that non-competes are most common among those workers. Among executives, for example, between 60 and 80% of them have non-compete agreements. For high-tech workers, it's closer to 50%. Physicians, closer to 50%. But when you actually look at the kind of broad representative samples of the U.S. workforce, the typical worker bound by a non-compete is not actually some highly paid tech worker. It's an hourly paid worker who makes at the median about $14 an hour. And that's because even though tech workers and executives are the most likely to sign non-competes, they make up such a small fraction of the workforce that the typical worker bound by non-compete is not of that kind of high status type.
How hidden are these, or is this something that most people are aware of in their employee contract? And, do they read it? Do they know what it is?
So non-compete agreements can be asked to workers at any time. I think there are several states actually which have taken this on. And I think that the common concern is that if you show up on the first day of your job and you don't know there's a non-compete, but then you're sent to HR, and in the big stack of papers that you sign on your first day, they slip in a paragraph that's a non-compete. At that point, you don't really have any time to consider it. You probably just sign it and then hope it doesn't bite you down the road. And you can contrast that with a more salient approach where the company is transparent about the non-compete, for example, with the job offer, so that when you sign up for the job or when you get the offer, you know how much you're going to make, you know what the non-compete is, you're not surprised by it later. But in many states, there's actually nothing to prevent the company from offering you a non-compete at any point when you are employed. There could be a merger that happens and new management comes in and asks everyone to sign non-compete agreements. It could just be the whims of a boss that comes in and says, oh, non-compete day, and asks everyone to sign. When it comes to what workers actually read, I just ran an experiment where we worked with a company and we randomly put non-compete agreements in workers' contracts. And we set it up such that we could study exactly how long they spent on each page of the contract. And the non-compete in this experiment was on page 7 of the contract. And I can tell you that 75% of the individuals who looked at the contract spent less than 10 seconds on the non-compete page, and about a third of them skipped it entirely. And so most workers are not, if the non-compete is buried on page 7, most workers are probably not reading it.
That's not at all surprising to me. I'm thinking of, the terms and conditions that you sign for agreements for a million things that people literally just scroll past and sign the bottom. So are there a lot of employees then that sign these agreements? It sounds like sign these agreements without realizing that they've signed them, leave their job, and then find out or have legal action taken against them?
Yeah, it can happen in a few ways. If you have a non-compete agreement, you're not aware of it. You go to take a job with a competitor, and in your exit interview, the company reminds you of what you've agreed to, and they ask where you're going. And at that point, they're going to tell you about your non-compete. They're going to ask you to abide by it. They're going to tell you that they expect you to comply, or there may be legal action. And if you go ahead and violate it, and then they learn that you've joined a competitor, and it's not that hard to learn that information, on LinkedIn or, through various employees who know where you've gone, then they can both sue you for violating your non-compete agreement, and they can also sue the employer that hired you for what's called tortious interference. The typical battle is over a preliminary injunction, and that's the first fight, is whether or not you can convince a judge that there is a legitimate business interest, that the non-compete agreement is reasonable, and you want the judge to say, okay, while we figure out the rest of this case, the worker's not allowed to join this competitor. That's typically the first fight, and that's usually where it ends. Only a small fraction of cases kind of move beyond that phase. Oftentimes, it's the company who is doing the hiring that doesn't want to get embroiled in a lawsuit that ends up dropping the worker. And then that's the worst case scenario for the worker, where they left their job, they've pissed off their prior employer, and now they've been let go from their what they thought was going to be their future employer.
Oh, wow. Yeah, it's a nightmare scenario of all of the things that you think could go wrong. It's probably, the last or not even on anybody's list.
And I just want to highlight that if you look at surveys of companies who have HR managers who are filling out these surveys, those surveys reveal that about 1/3 of companies use non-compete agreements for every worker, which is how we get non-compete agreements in janitor contracts. It's how we get non-compete agreements in contracts for nonprofit workers who are volunteers. They become part of the boilerplate. And I think it's really important to realize that they are actually quite common because companies have adopted this kind of broad boilerplate approach to non-competes.
I wanted to go back to, you mentioned going as far back as the 1800s that some states started to take action, and that there were, kind of already bans on non-competes in a few states.
There's a wonderful article by Ronald Gilson, who's at Columbia Law School in 1999, who traced the history of the California statute, which is the most famous And it's because of all the places, Silicon Valley is located in California, and California banned non-competes in 1872. So I know a little bit about that history, which is that there was a guy named David Dudley Field who initially wrote this non-compete ban for the city of New York, for the state of New York. And New York decided not to go with it, but somehow that law then got passed over to California, and the California folks did pass that. And so that's sort of the history of the California rule. But I think maybe more interesting is this debate, which this Gilson article brings up, which is that if non-compete agreements were so important for innovation because they would spur a company to want to invest in their workers or share proprietary information or develop trade secrets, then how is it possible that Silicon Valley arose in a state where non-compete agreements have been banned since the late 1800s? And the argument that Gilson makes, and that there's some more recent evidence of, which is really interesting, is that effectively, if companies can only ask their current workers to sign non-compete agreements, and if every company is doing this with tech workers, and your company's not doing it, then you're not able to hire their workers, but they're able to hire from you. And so your private incentives as a company are to try to lock up your workers with non-compete agreements. Workers are not starting new companies. They're not pursuing ideas. Companies are not able to hire the workers that they want to hire to pursue, new innovations or whatever it is. And the problem then is that the companies themselves are in their own way. Even though they're doing what is optimal for them, from a social perspective, we're all worse off. And Gilson's hypothesis was that maybe in that case, a ban on non-compete agreements is the right way to go. You look at the history of Silicon Valley, there are a bunch of companies that were founded by, especially in the semiconductor industry, they call them the Fairchildren, which are these companies that spun out of Fairchild, where employees left and started their own competitor. And so the kind of blood of Silicon Valley is this ability to leave and start something new.
That is fascinating because it does kind of disprove the fundamental argument of non-competes. So let's talk about April and the nationwide ban proposed by the FTC. As we mentioned earlier, it has an exception for senior executives who have existing non-competes in place. That kind of makes sense, I think, to a lot of people. Is there anything else in the ban that the ban doesn't cover? And kind of what's the current, I know it's getting a lot of pushback. What's the current state of it? When does it go into effect?
So the current state of it is that the FTC has been sued by three parties at least: Ryan LLC, the Chamber of Commerce, and a third company. And there's a judge in Tyler, Texas, who's overseeing the case. I believe there's going to be a decision on it before July 4th. So we should know by July 3rd what the outcome is. If the FTC wins and the rules allowed to go into effect, I think it's going to go into effect sometime in September, was what I saw recently. So what that would mean is that in September, all non-compete agreements going forward are banned. You're prohibited from even entering into a non-compete agreement. It's not just that a court won't enforce it, it's that the prohibition is on entering into a non-compete agreement. I think there's some interesting pieces of the law.
Does it cancel ones that employees have already entered into?
If they're not executives, then yes, it would rescind existing non-compete agreements.
What's the argument in favor of keeping non-competes, and is the argument likely to win? I mean, obviously, we've talked about the companies will share less with their employees. It'll stifle innovation, like that sort of old argument. Is there a new argument that's being made? And in your opinion, having studied this so closely, what do you think the outcome will be?
There are two arguments that are being put forth for the most part. One is that the FTC doesn't have the legal authority to make this rule. And there are the folks at the Chamber of Commerce, for example, they don't want the FTC making rules that regulate business in this way, even as they relate to competition. And so they're making a bunch of claims that the FTC doesn't have the authority. And part of that is they're claiming that the empirical evidence isn't there to support it, and therefore the rule is arbitrary and capricious. My sense is at least the evidence is there by and large, and that the FTC is acting in a way that is consonant with the empirical evidence. And there is, at this point, just a growing body of evidence of the harms of non-compete agreements. And I'll just give you a few examples. One paper that came out recently by Matt Johnson, Mike Lipsitz, and Allison Pei, and there's a similar paper by Emma Reinmuth and Kate Rockall at Stanford, which looks at how innovation changes when state policies regarding non-compete agreements change. And what they find is that when states begin to enforce non-competes more vigorously, that innovation falls. even though, and this is the key, even though firms invest a little bit more, overall innovation falls. And it's not just a reallocation from one state to another state, but it's a kind of a global loss in innovation. And they're able to tie this loss in innovation to workers being less likely to change jobs, start new companies. Even unenforceable non-compete agreements can still chill worker mobility. Many state approaches to non-competes have been, okay, we're not going to enforce those. But the damage is sort of done well before that. Because even if the court wouldn't enforce that, the worker typically acts like it's enforceable, even if it's not.
That's such an important point, because if you don't know that it's not enforceable, you don't know what will happen. It's just you get the threat and you back off, and yeah.
That's right. And the other thing that I want to mention is that the FTC is really keen to highlight this effect of non-compete agreements on other workers. I have a study in 2019 with Justin Frake and Rashri Agarwal where we looked at labor markets where the use of non-compete agreements is very common. And those labor markets tend to be less dynamic. You have fewer workers moving across jobs. You have lower wages, and those lower wages extend to everybody in the labor market, not just the workers who have non-compete agreements. And when the FTC says non-compete agreements affect competitive conditions, that's what they're talking about, because it affects the whole labor market, not just the workers who are bound by them. It adds up to a slower moving labor market that affects all the workers. That's a really important justification for the FTC's proposed rule.
That's an incredibly compelling argument for it, yeah.
There are many other tools that firms can use to protect their intellectual property. They can use non-disclosure agreements. They can use agreements not to solicit clients. They can use trainee repayment agreements, where a worker, if you're going to go pay for work to get an MBA, they can go get the MBA. And if they leave before a year, they can pay back some portion of that training. Those are all alternatives to non-compete agreements that are directly tied to the business interest, whether it's secret information, whether it's clients, whether it's training. The non-compete agreement is sort of a catch-all to protect all of those things. And so we should think of non-competes as how much extra protection is the company getting with the non-compete relative to these less restrictive alternatives. This is, I think, where there's a lot of questions about how much do firms really need non-compete agreements versus like NDAs, for example.
I'm so glad that you brought that up. Hopefully, I'm not the only one that has a little confusion over these things. How closely non-compete clauses are related to non-disclosure agreements? And if employees require one, are they likely to require the other? What are the impacts of NDAs and the legal status there?
So these operate differently. They often get confused. So, a non-disclosure agreement allows you to leave for a competitor, but it prohibits you from using or disclosing proprietary information that you learned at your former employer. And so it's different from a non-compete because a non-compete prevents you from moving in the first place. So the non-compete, the prohibition is on moving to a competitor. An NDA is the prohibition is on sharing or using information. And so the difference is when it comes to enforcement. A non-compete agreement, it's generally pretty straightforward to observe a violation of a non-compete agreement. And because a worker was employed by company A, they're now employed by company B. Company B is a competitor, therefore you violated the non-compete. That's a pretty easy to observe thing. It's much harder to observe whether a worker has violated a non-disclosure agreement. If companies are secretive in how they're extracting information, if workers are being savvy and thoughtful, it may be hard for the company to detect whether that individual has stolen any information. And so this is the argument that folks make for non-competes over NDAs, which is that if you really want to have a kind of a prophylactic, protective measure that precludes information sharing in the first place, the non-compete is the way to go. The NDA works only ex post after information has already been revealed, and you may not even be able to detect it. And so that's the kind of trade-off that lawyers will talk about. And it's sort of an empirical question whether or not NDAs are effective. And if NDAs are not effective, then maybe you need non-compete agreements. And if NDAs are very effective, then maybe the non-compete is just preventing a move that the worker would otherwise like to make, but is not adding anything extra to the protection of the company's legitimate interests.
Going back to the FTC ruling about non-compete agreements, one thing that was really eye-catching in it was the claim that it will raise wages by $300 billion. Can you talk a little bit more about how non-compete agreements impact wages?
Absolutely. Yeah. Thank you for bringing that up. So the best evidence we have on non-competes and wages is from some state level policy shocks where I think I mentioned in 2008, Oregon banned non-competes for low wage workers. Hawaii banned non-compete agreements in 2015 only for high-tech workers, which is a very interesting ban where they left non-competes for low-wage workers intact, but ultimately banned them for high-tech workers. And then over the last several years, we've had several state-level bans on non-competes below various earnings thresholds. So this would be like in the state of Washington for workers making under $100,000. In DC, it's below $150,000. What you find is that after these bans come into play, wages tend to rise by about 3%. Give or take a few percent here or there, but about 3% is the rise. And so if you take that 3% and you multiply it by the total earnings of workers, that's how you get those numbers in the several hundred billions of dollars.
If you're an employer and you're listening to this, what would your advice be towards what things to put in place, how to think about non-competes, how to think about employment contracts?
Yeah, it's a great question. There's two things I would say. One is that hopefully employers are on notice that non-compete agreements are in the crosshairs at the national level and at the state level. And I anticipate we'll see continued restrictions on non-compete agreements, even if the FTC rule is overturned. So I would say prepare for a future without non-compete agreements, and make sure that your information is protected. Your NDAs are narrowly tailored. Your non-solicitation agreements wouldn't fall under a kind of a de facto non-compete or be so broad as to be construed as a non-compete agreement. And then I would say anticipate being able to hire from people in your industry that you weren't able to hire from. So make a list of all the employees that you had to pass up over the years that you would have loved to hire. Figure out the strategic direction your company wants to go and the types of employees and talent that you want to be able to hire. And once that ban goes into play, then hire those people and go in the direction that you want to go. I think that it's really important because often you'll hear the first part from lawyers, which is protect your information in other ways. But it's equally important to say, about 20% of the labor market is about to be freed up and able to move. And that's a huge opportunity for employers because employers can now hire the workers that they want to hire and workers can join the companies that they want to work at. And so there can just be this hugely productive reallocation of workers across companies that can spur productivity, can spur innovation, and make workers and firms both better off.
That's fantastic advice and a fantastic way to look at it. If you are an employee and you're listening to this, and you're like, I don't even know if I've signed a non-compete, or I know that I have. Is your advice in this moment to like sit tight? Everything might be all right. Is there a way that an employee can negotiate with their employer to have it taken out of their contract?
Yeah. So the first thing I would say, if you're an employee, is to review the policies of your state. And depending on where you are, your non-compete might already be unenforceable. And if it's not already unenforceable, you can always try to negotiate out of these things. It's possible that your company knows non-competes are on the outs and they would rather, have you pay them $1,000 to get out of a non-compete or have your new employer pay $1,000 and let you out of it. That's definitely possible. Or wait it out. And shortly for these workers, there may be new opportunities on the horizon if this FTC rule does go into effect.
It sounds promising that we'll hear that this will be passed and this will be the new law of the land in around September. Thank you so much for walking me and our listeners through all of this. I think it can be a really kind of confusing and overwhelming topic, but laid out like this makes a lot of sense.
Thanks, Kate. It's been a pleasure.
And that's all for this episode. If you're a new listener, be sure to subscribe to The New Way We Work wherever you listen. And if you liked this episode, leave us a rating and review on Apple Podcasts. And we want to hear from you. Work is changing every day. What's the most pressing issue on your mind? Email us at podcast@fastcompany.com. The New Way We Work is produced by Julia Shu, Avery Miles, Blake Odom, and Joshua Christensen with editing by Nicholas Torres.